This is Chapter 5 of the Law of Journalism and Mass Communication. We're dealing with libel, its defenses and privileges, and we are moving right along to Section 230 immunity, which is dealing with the Federal Communications Decency Act of 1996. Now, the authors want to make a big deal out of this, and I think they're overstating a lot of things. Essentially, this is going towards whether somebody owns the content that's being published or whether they're merely the conduit. We talked a little bit about this in the last chapter and dealing with publishing. And the Communications Decency Act, or CDA, applies to ISPs. It applies to internet service providers. So if they didn't create the content, if they were only a distributor, or if they didn't interact directly with the content, then they're not going to be held responsible. They can't be held liable for the libel. Also, it's possible for these ISPs and for the websites to go in and make corrections to clerical errors to the content, and that still won't make them content creators. Just because they've put their hands on it doesn't mean that they've done any real substantial creation. So as long as they don't substantially alter the meaning of the content, then they're not going to be held responsible. There are cases that are mentioned in the book dealing with America Online and Verizon and Facebook, and we talked before about Twitter, and all of these fall under the CDA. And again, this is with the content distributors, and it's the idea that if you own the content, you can be held liable for the libel. Going back to that same concept that we talked about last chapter with republication, vendors and distributors, it's not the same thing as publishing. They don't create the content, and so they are not responsible. So that goes towards newsstands and libraries and bookstores, and that applies to internet service providers. So the CDA specifically deals with the internet. And again, we talked about this in the last chapter. The example that we had from the last chapter was Zarin versus America Online. So ISPs and websites are not responsible for the content as long as they didn't create it. Now, the textbook goes further to show that even if the ISPs and the websites, if they've taken some sort of action, that still doesn't rise to the level of content creation, and they can still qualify for this immunity under Section 230 of the Communications Decency Act. If the website or the ISP is soliciting or encouraging users to create content, that's not the same as creating content, and so they're not held responsible for that. If they pay someone to create or submit content, that is not the same as creating the content, and they are not responsible. And if they provide forms or drop downs to facilitate content that's going to be submitted and created by users, so long as these forms are neutral, they are not responsible, and they qualify for this immunity under Section 230. There is a nice, quick summary analysis that is in the textbook on page 210, and walks you through the analysis. Do ISPs and websites get this protection under Section 230? If they are a distributor and not a creator, yes. If they did not interact directly with the content, yes. And this protection applies when these ISPs and websites have de minimis or minimal interaction with the content, such as correcting clerical errors or correcting grammar or punctuation, or if they're soliciting other people to create content, they're not creating the content, they're requesting or encouraging users to create content, or they're paying a third party to create content, or where they have forms or some other system where they are going to try and facilitate creation by the users, as long as those forms of that system is neutral. That's it. This is a pretty good summary right here of how this immunity under Section 230 works. Now, the authors talk about some emerging law with Section 230 immunity on page 213, and I actually think they do a lousy job in explaining this. They talk about this, they're talking about a workaround where ISPs and websites, now the way the law is interpreted, where there's no protection under Section 230 under the CDA, and I think that's pretty much garbage. If you read this, they talk about the case with Hassel versus Bird, where a content creator, somebody went on to Yelp and gave a negative review, and it was false under following the analysis for defamation, for libel, and the court ordered that those statements be removed. The defendant wasn't able to do that, and the court ordered Yelp to remove that content. The explanation that's being provided here is that this social media provider, Yelp, is somehow being held liable for the content, and that's not the case. They're being ordered to remove the content. They're not being subject to anything other than complying with. They're not being subject to damages or anything where they're going to have money out of pocket, or that it's going to be any sort of major inconvenience. So I don't think this is a good explanation where the authors are trying to put this as a workaround for the immunity. I just don't see this. You can read this little sidebar and come to your own conclusions.